some courts will deny discharge. In a Chapter 13, let's say it's a 5-year plan. So they're making their payments, they're supposed to be making their payments over the course of 5 years. If they've done everything they're supposed to do at the end of 5 years, they get a discharge, meaning that debt's been discharged. It's been satisfied, resolved, right? But some courts have found, when they get to the end of the case, if they've not been making ongoing payments to creditors, mortgage creditors, car creditors, a court may deny discharge at the end of the 5 years because they're in arrears with their mortgage again, for instance. So conduit plans are a way that a court, the trustee can keep track of that. That's really more of an FYI for you, but it's good to know. Go ahead.
Is Utah kind of moving towards that as a?
I don't think so, and this is why, because so the new plan went into effect in December, what year are we in?
2015?
It's December of 17, I think, is when the new, so Utah adopted a new plan. In fact, most of the states across the U.S. did, because it had to either be a plan that matched the preferred plan, or it had to include all the elements of the preferred plan. So Utah adopted its plan, I think, in December of 2017, and it didn't. There's nothing in the local rules about it. There's nothing in the plan about it. I don't know if the Rules Committee is looking at it. They may well be. I'm not on that. But I don't have any, not that I'm aware of, right? I don't think conduit's in the works here. Yeah. One drawback of conduit from the debtor's perspective, of course, is that the debtor pays a fee to the trustee on everything, right? So if the debtor has a $1,500 mortgage payment and the trustee's fee is 10%, then the debtor has to pay that additional $150, right? So they have to pay $1,650 to the trustee then takes $1,500 of it and sends it to the mortgage. So there are drawbacks to it, right? I can see the practical purpose behind it, but there are some drawbacks to it.
I have a question.
Go ahead.
So how does it affect if they're a married couple and just one is going to file? Does the spouse get protected somehow if they're not, like, you're not on their debt, but they are filing, but then you have a home, you have things together? Is the other person that's not filing, are they protected somehow?
There is. It's called the co-debtor stay.
Okay.
Co-debtor stay, but it's specific to a 13. I'll actually find that code section. I'll give it to Leora and she can get it to you because there is a co-debtor stay that goes into effect with regards to, let's say that my wife and I are both on the mortgage, but I'm the only one that files bankruptcy, right? The creditor would still have to come get stay relief in my bankruptcy and also get relief in the co-debtor stay to be able to move against a joint debt. So the spouse, the joint debtor has some limited protection in bankruptcy. Yeah, so same with the car, right? The creditor couldn't come take the car if they're both on the loan, but only one of them filed bankruptcy. And that may even extend, in some instances, to like a spouse who's not the co-debtor, right? So it could, the co-debtor stay. Yeah.
What if they're not on the mortgage and just the one that's not filing is on the mortgage? Do they have a right to take anything from the mortgage, the house? Because you're married in Utah? Does that apply to anything?
No. So you're saying if the borrower, let's say that the mortgage is in my wife's name only, and I'm the one that files bankruptcy, but I live in the home. Yeah. It boils down then to title, right? Because if the home is only in her name, she has a mortgage on the home, and I file bankruptcy, then the bank could still foreclose without having to get stayed in my bankruptcy. However, if we're both on title and she filed bankruptcy, then they'd have to get stay relief because I was on title. Yeah, there are nuances to the co-debtor stay. Generally, if there's a spouse, we'll ask for it, right? It will file a motion for relief and ask for it, just to be.
Yeah, because if you divorce, everything's split. That's why I was wondering if bankruptcy, is it also going to affect the one that's got good standings?
Absolutely. That's a good point. I'm glad you brought that up. Because bankruptcy courts don't recognize divorce decrees, right? So, I mean, I'm sorry, that's not fair. They do recognize them, but if my wife and I are on the mortgage together, we both signed on it, we get divorced, and I take the mortgage, right? Even if the divorce decree says I take the mortgage, contractually she's still obligated on the mortgage because the bank never agreed to have me assume the mortgage solely, right? And so in that instance, yeah, you bet. And as you know, it happens often, right? When assets are split in the divorce, but they're actually still joint debts, right? And yeah, so in that instance, the creditor would have to the creditor could collect from both and would have to get stay relief if either one of them were in bankruptcy.
That's why it's really important when you get divorced and that happens, you make whoever keeps the mortgage and the house, you make sure that they refinance that house, so you are no longer on that loan.
You bet.
Because they will drag you into a bankruptcy if, you know.
Or into a foreclosure or into a
Yeah.
post-foreclosure deficiency case. I'm dealing with one of those in Nevada now where the problem was, it was when the market was so bad, there was no way to refinance it, right? But one spouse, they got divorced, one spouse continued to work, the other spouse lived in the house, didn't make the mortgage payments, right? But now the spouse that, you know, had good credit, was taking care of her own debt, got you know, the property got foreclosed, there was a substantial, well, a decent sized deficiency, and when we sued both of them.
Yeah.
Right, because
And
they're both.
And it destroys the other person's.
That's right.
You know, it could be, yeah.
Yeah, that's right. So back to your question, that is, in my mind at least, the co-debtor, there's a difference between the co-debtor stay and the creditor dealing with, like somebody who's been divorced, but still they're joint on an account or joint, you know. Yeah. So the co-debtor stay would apply in that circumstance, but there are other issues that come up in that circumstance where there's a divorce, but they're both still on the mortgage, for instance.
Okay.
Right. Chapter 11, just very briefly, we do a lot of Chapter 11 work, but I straight up acknowledge that we deal with a sliver of Chapter 11 work. It's all secured creditor work, right? It's mostly mortgages. So we do a lot of them in Nevada and in Arizona, but with rare exceptions, most of these debtors are people who bought multiple properties, right? So they're individuals, but their secured debt load is above, I think it's $1.2 million. So it pushes them out of what being available for a Chapter 13, pushes them into a Chapter 11. So we deal with the Chapter 11, but it's mostly because it's still a consumer mortgage is what we're dealing with, right? But with regards to Chapter 11s, it really is, it's more like bankruptcy. I'd say if you come across, it's more like litigation. If you come across a Chapter 11 and you're not really sure, don't treat it like if you would a Chapter 13. Don't just go look at the plan and figure the plan's going to lay it out and you'll be fine, right? Because the ones we deal with are ones, we often deal with them in Chapter 11 where there's been, a motion was filed early on that crammed down the mortgage or that modified the mortgage or whatever it was, right? But if you look at the plan, it may not say that. It may just refer back to the document. We end up with a lot of litigation where debtors are coming back to us saying, often in a Chapter 11, debtors are coming back saying, look, this loan was either paid off or modified or something in the course of this Chapter 11. You didn't properly rebook it, and here you are, you're still trying to collect it from us, right? So Chapter 11s, just be really careful with Chapter 11s. I mean, there are first day motions that have to be filed if you're a secured lender, like a bank, or if you're a secured creditor, if you're a mortgage creditor with assignment of rents, and somebody files, and then files Chapter 11, they're going to ask the court to be able to use cash collateral, which is basically your money, right? They want to use the money that they'd be paying the mortgage to pay their plan, right? So watch for those first day motions, watch for 506 motions, meaning that's crammed down. You just have to pay close attention in Chapter 11. We're right against time, so let me just say in a Chapter 11, on a mortgage, for instance, the Chapter 11 plan can say, so backing up a little bit, a Chapter 13 plan has to be finished in up to 5 years, right? It's not necessarily true in a Chapter 11 plan. Often it will happen that the debtor will come in a Chapter 11 and say, look, you know, this is a rental property. I owe you $300,000, but it's only $250,000. I want to pay that $250,000 at a reduced interest rate over a new 30-year term, right? And courts will order that. And so often we'll stipulate to it, right? So it may completely modify the mortgage. It may reduce the amount that's owed, reduce the interest rate, and set a completely new term over 30 years or however much it is. So you've got to be really careful in a Chapter 11 that you're paying attention to it, or have somebody paying attention to it that knows what to look for. Let me go back then to the two things that I brought up initially: automatic stay and discharge injunction. These, from a creditor's perspective, you need to be most careful with these, I think, because it's the easiest way to get yourself into trouble with the bankruptcy court. Automatic stay, let me address that very quickly. If a creditor violates the automatic stay, and I'm looking at, I've just pulled a decision came down in a case that I'm in, so I pulled the judge's opinion, just so I make sure I didn't make a mistake in quoting it. But it doesn't matter if the creditor intended to violate the automatic stay, because no creditor is ever going to intend to violate the automatic stay, right? All that matters is, did the creditor know, or should the creditor have known, that the stay was in effect, and did they intend the action that violated the stay, right? So if debtor files bankruptcy and the credit union picks up the car, repos the car 10 days later, there's a good chance that's a stay violation, right? They could have run a bankruptcy search to see if the stay was in effect at the time that they picked up the car, and the action violated the automatic stay, right? So the creditor doesn't, again, have to intend to violate the stay, simply has to intend the action that violated the stay. This is what's available in a circumstance where the stay is violated. This is under 362K. They can recover actual damages if there are any. Let's say in that car instance, the car is repossessed and sold. So they've lost the car. They've lost the value of the car. That might be actual damages. Attorney's fees and costs, and punitive damages, right? So in a stay violation, the court can award punitive damages. And let me tell you, bankruptcy courts generally are not, it's not that they're not allowed, because, well, what's the best way to say this? The district courts, generally they don't want bankruptcy courts awarding enormous amounts for punitive damages, right? Bankruptcy courts have to be very careful about what they award of punitive damages. But in this particular instance, they're allowed to award punitive damages. I'll tell you in the case, and I won't tell you which one it is, but the court awarded $22,000 in this case. The decision just came down a couple weeks ago, $22,000 in punitive damages, in addition to 12 or 13 in attorney's fees. But $22,000 in Utah, I think, is a big award for punitive damages, right? So that was a big one. So be really careful about the automatic stay. My last comment is with regards to the discharge injunction. So in a Chapter 7, after when a discharge is entered, so they file a petition, assuming everything goes swimmingly, the trustee's okay with everything, the debtor gets their discharge. That means the debtor no longer is individually or personally liable for any of that debt, right? Same thing happens in a Chapter 13. They file a Chapter 13 with a plan. If they complete the plan 5 years later, they get a discharge, meaning they don't owe any of that debt anymore, right? So if a creditor tries to collect that debt, or tries to take collateral that they're no longer entitled to take, then the bankruptcy court can. Now it's now under the bankruptcy court's contempt powers, right? Because now we're talking about a bankruptcy order. The bankruptcy court has issued this discharge. That's a bankruptcy order. And if the creditor violates the order, then they're in contempt of court, right? And in that circumstance, so let me give you a quick example. This is a Chapter 11 case. The creditor, in the course of the bankruptcy, so the bankruptcy plan in a Chapter 11 said, we're cramming down what we're paying you, and we're going to pay you over the course of the plan. So over the course of several years, it was 5 or 8 years, whatever it was, the debtor actually paid off the modified debt, paid the secured debt completely, right? Got their discharge. And as soon as the discharge was entered, really almost immediately, the creditor started a foreclosure action on the property, right? And nobody caught the fact, nobody rebooked the loan, that's what happened. So the creditor didn't catch the fact that it wasn't owed any more money. Had it rebooked the loan at the time the plan was confirmed, then it would have been collecting the payments along the way, and it would have been done as soon as the discharge entered. Or it could have objected saying they haven't paid me everything, whatever the case may be. But in this instance, they didn't, right? They started a foreclosure. And even after the debtor's attorney went to them and said, look, we paid this off in the plan. You're not owed a cent anymore. They still proceeded with the foreclosure. Gratefully, we got involved before they actually foreclosed the property. But in a circumstance where a creditor violates violates the discharge injunction, the court can award actual damages, which include emotional damages. And there are 3 cases that I'm aware of in Nevada. One where the court awarded a debtor $30,000 in emotional damages, one where the court awarded $60,000, and one where the court awarded $111,000 in emotional damages. And let me add, by the way, with no medical records, with no testimony from an expert or a doctor, a treating physician, none of that. The court awarded emotional damages as actual damages and awarded an enormous chunk, right? So they get actual damages, which include emotional damages, fees and costs, and what the case law refers to as a mild non-compensatory fine, which is basically punitive damages, right? But those are not big amounts, usually $2,000, $5,000. But the point is that discharge injunction violation, that's a court order. Once that's been entered, if the creditor violates that, then they're in contempt, it's in contempt of court. And the damages could be enormous, right? So again, wrapping it all up, if you don't take anything away from this, and you probably all deal with this all the time, don't violate the automatic stay, don't violate the discharge injunction, right? Because then your creditor's gonna get they're gonna get in trouble with the court. Does anybody have any questions? All right, go ahead.
1 second. Maybe everyone already knows the difference between when you call a bankruptcy case and it says dismissed, this date, discharge, closed. Discharged is 13th, right? It was discharged, but I mean, basically look at something and go, oh, okay, case dismissed, but that's different than case closed.
That's a very, very, very good point. Dismissed means the case, there's no discharge, right? It means that the creditor or the debtor did not do what he or she or it was supposed to do and the case was dismissed. Yeah, you're absolutely right. And discharge means that the debtor did what he or she or it was supposed to do and got the discharge. You're absolutely right. That's very important. And it's important not to mix those two up, right? Don't treat a dismissal like a discharge or vice versa. And closed is also a very important distinction, and this is why. This is less so in Utah, at least for us. But as long as the case is open, even if discharge has been entered, the trustee still has jurisdiction, has authority. Jurisdiction is probably not the right word. The trustee still has authority. So in a case where discharge is entered, and we get a referral for a motion for relief on a mortgage or a car, even if discharge is entered, we'll file a motion for relief. Because our argument's going to be, look, we're looking for a comfort order, right? Discharge is entered. Stay should be terminated. We should be able to proceed, but the case is still open, which means the trustee still has a right to take that collateral, that asset if they want. But yeah, so they're definitely, that's a very good point. Those are 3 very distinct things that can happen in a case, and it will affect the creditor depending on which it is. Very good point. All right. Thank you.
Thank you.